You know, I was thinking of a similar question to Justice Alito, that you could have the rule that you're suggesting here, and it's the rule that I do think follows from Boyle, which is that the contractor is liable as long as the military didn't specifically approve or direct the conduct. But you could have a more deferential rule, which still allows some forms of state liability to come in, which is that the contractor is liable if but only if the plaintiff can show that the contractor violated military policy. In other words, so in this set of circumstances of the kind that Justice Alito was given, where the government doesn't really say one way or the other, maybe doesn't say anything at all, or maybe leaves it to the contractor to decide, their liability would not be all right. Instead, liability could come into effect only if you could show that the contractor violated military policy. What would you think of a rule like that?
We would certainly be okay with that rule. Certainly, if the court is already thinking about creating some sort of a federal common law rule in this area, we think it should be the one that furthers the government's interests by avoiding contractor negligence and incentivizes contractor adherence in a war zone. And this ended up injuring multiple U.S. soldiers on the base because Fluor didn't do what the Army told it to do. So if we're thinking about what kind of rule applies, the rule has to be one that saves soldiers.